Hello everyone, welcome back to another episode of the Darrell Brooks saga. On today's episode, we finally made it to the first day of trial, the proper first day that Darrell's gonna be defending himself. And as you can see, he has his boxes right here. He's ready to go. He has all the material that he needs for his defense. Before that, I just want to say thank you guys for being here. I just want to remind you that you're great. You're awesome. I am glad that you're here. I really cannot say thank you enough for everything that you guys do for the channel. Thank you guys for subscribing. Thank you guys for liking the channel. Thank you guys for putting your comments. One thing that I wanted to do is that if you guys can comment in new trials or something that you want to see after this, because this is the last day. After we finish with this, I'm gonna finish my Shanda trial that I have pending, and then I would like some ideas of what you guys want to see. But without further ado, let's go right into the video.
The defendant, Darrell Brooks, appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
Less than 15 seconds of getting into trial and he's already objecting. Oof.
Name and would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights, if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr. Brooks, it wasn't the proper time to do that. That's now the third interruption.
With all due respect, Your Honor, every
Mr.
time
Brooks,
we...
by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
But it is
I have
right
a number
to,
of documents that I need to discuss this morning.
Right
Mr. Brooks, you do not have a right to interrupt the court.
No,
I will remind you once again of the Supreme Court rule. I checked, I verified, it is.
I accepted in return
Mr. Brooks, that's yet another interruption. Let me get through this, please.
I just want, for the
You
record,
will have an opportunity when I give you an opportunity. No one else is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's another interruption.
I intend to follow decorum.
This court comes with a history of Mr. Brooks interrupting now. I am well aware that's another interruption. I'm well aware. Stop
respectfully,
talking.
which I have the right to do.
I'm well aware, Mr. Brooks, that you object to the name that has identified on the information and all documents in this case. Your objection is noted. It does not need to be repeated. I will make a record right now. The court notes a continuing objection by Mr. Brooks of
I wanted to let that interaction go because that sets the tone for the rest of the trial. I mean, we've been going at it for almost 3 minutes now. And he's been saying the same thing over and over and over and over again, even though the judge just said that, all right, your objection is noted, whatever, but I'm doing my thing. I need to finish saying this. So shut up. And he's like, nah, I'm just going to keep talking.
His name and that he objects to being here. I know he's filed a number of documents previously related to that. Those documents are of record. There's another document that's filed at least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio means to participate.
To being removed from the courtroom, Your Honor.
That's another interruption.
And you haven't shown me any lawful case law that I can be removed from the court proceedings in a trial and forced under coercion and duress to appear.
He doesn't even know how to say coercion and duress. There's coercion in duress. He doesn't even know the words that he's speaking of.
In the trial that I am needed, that I'm trying to express that I have the right
Mr. Brooks, there's a proper manner in which you raise objections. You have not followed that proper procedure. You are unable or unwilling to abide by simple rules of civility. You interrupt, you don't wait for anyone to finish, and it will result with you being removed from the courtroom. So you are once again reminded of that. I would like you to appear in street clothes. It is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so.
You being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial.
I think we all know why he doesn't want to put on the suit. It's because he's afraid of Suit Watch. And if the real OGs of the channel know about Suit Watch, like I'm gonna give you a little tease right there. He's afraid of that symbol. But other than that, she's right about why she wanted him to be in a proper clothing, because appearing in prison uniform gives the jury the impression that he's already guilty, that he needs to be in this clothes. So putting on a suit gives you like a good look for the jury, and you need to convince the jury if you want to win this trial.
Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever.
Mr. Brooks, did you hear the question that I asked you?
And I respectfully keep the position that I just put on the record.
Mr. Brooks, I will ask you again. Are you willing to go back to your cell or into the jail and put on street clothes?
I do not consent or agree to anything that you just stated, Your Honor.
It's a yes or no question. You can just say no. Just say no, and that's it. That's what you want to hear.
Let the record be very clear that Mr. Brooks was given multiple opportunities to answer that question. And go back. Mr. Brooks, that's yet another interruption. You refuse to answer my question about whether you would go back to.
Again, it's the same thing that he does this all the time. Like, you ask him what day is today, and he's like, it's raining. Like, he answered the question, but not with anything of value to what I asked.
To the jail, that's another interruption. So based on his refusal and his choice to come, that's another interruption. Based upon his failure to answer my question directly, I will take that as a non-response, but he came to court here today. That's another interruption. No one has forced him to come to jail in those clothes. This court.
He keeps interrupting. Like, I'm annoyed. I'm annoyed. Like, look at the face of this guy. Like, he's annoyed as well. Like, we are all annoyed with this guy. And I don't know how she's able to keep it together to and not just get him out of the courtroom. He's going to continue to do this. He's not going to stop. She should send him back to the other room.
It is encouraging him not to, but it is his choice to not do that, and we will proceed accordingly.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you may not, sir. You need to file a motion in order to do that.
So
Mr.
the
Brooks?
motions I filed haven't even been responded to. I gave
Mr. Brooks, you're interrupting me yet again.
You just weren't speaking.
All right,
so
Mr. Brooks, you are now going to be removed to the other courtroom.
I don't consent to that.
I have had a dozen or more interruptions. You'll be off the record while we do that. Thank you, everyone.
I don't agree to a stop.
And this is the first time that he mentions that he has shock. So someone told him, like, I do believe that when they were putting the chains on him, like some guard or someone told him that they were a shock device, and he latched onto that. But they're just chains. He doesn't have any electronic device on it.
Well, I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I do not. I have a right to be present for trial.
Actually, according to Illinois versus Allen, he can be removed from the trial, and he doesn't even need to be in another courtroom. They can just send him back to jail, and they can continue with the trial without him. Like, it's not a requirement that he's in the courtroom, or he could be gagged or held in contempt, but you know. And he takes off his shirt for some reason. Like, you're a skinny guy, my dude. You don't need to do that.
All right, we are back on the record. Appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility.
And also notice that he's giving the back to the camera. Like, he's like, yeah, I'm not gonna see you. I'm gonna just stand here and look at the wall. I'm not complying with your procedures.
He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case.
15 seconds.
At the moment, he is muted because of the way that he was removed from the courtroom and his conduct since. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. If at any point in time he wants to come back, and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings for all individuals in this courtroom.
Look, and now he's mimicking that they hurt him, that they did something to him while he was being carried to the other courtroom. And maybe that happened. Maybe they had to hold him in case he needed to, because he couldn't stop moving, or he was trying to throw a shoe or something. But if he would just comply, they would just carry him to the other courtroom, that he would sit there and nothing will happen. Like, this is the consequences of my actions coming back to me. And he's like, oh no, now the whole world is at fault because of that.
Including Mr. Brooks himself, then he may come back in. It's also my intention to give him that opportunity at each new stage. Since going back on the record, Mr. Brooks still appears to be communicating, or at least attempting to communicate with someone else. I can see his hands moving. He has turned his back. I can tell that he can hear me because he shakes his head no at a point in time where it's clear he's disagreeing with something that I've said. I believe he can adequately hear, and that his statement earlier in the proceedings that he's hard of hearing is simply another tactic of his to disrupt, to delay, to create chaos.
I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a duty to raise any concerns as to the competency of any defendant to proceed to trial, and the court itself, if it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14. At no time has anyone involved in this case had a competency concern. You've made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on, as to some of the discussions he's had with other individuals. He makes multiple phone calls every day, and they are all listened to. He knows the issues in the courtroom. He discusses what happened in court that day with these individuals he's speaking to. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion. Anybody that thinks otherwise has no involvement with this case.
Yeah, I agree with Susan Upper. Like, I agree that he's capable of doing, he's unwilling to do it, but he's capable of standing trial. He's not crazy in that way. He has an attitude problem, but he is by no means challenged in that aspect.
Drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case. So he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized by a jail employee so that it is a signed and sworn affidavit. Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
Thank you, Attorney Opper, and I do appreciate you raising that with the court. I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face-to-face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. We are at the stage where we are at with Mr. Brooks muted in another courtroom because of his defiant actions. No one else. And I appreciate everyone's patience as the court goes through these things, frankly, gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so.
And it's really important that they put all these things on the record before starting the procedures, because it gives the record of, they know that these are antics. They know that this is just him misbehaving. Like, he doesn't care. He doesn't really, he knows what he did. And he said so at the end of the trial. Like, he knows that he's been guilty from day one. And he's just here basically because he doesn't want to go to the actual prisons. He just, I don't know if it's jail or I think it's prison, the big one. So he knew what he was next for him, and he didn't want to go there. So tried to stall for the longest time.
What I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions. I will make a record that Mr. Brooks did not file anything in writing regarding a proposed jury instruction, as he was advised to do yesterday. If he wanted me to consider something, I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. Has the state had an opportunity to now review the preliminary jury instructions with all the changes that were made yesterday?
We have.
Any objection to those?
No.
All right. Mr. Brooks, I'm going to unmute and ask you if you have any objection to the jury instructions that were provided to you yesterday. I'm specifically looking for a yes or no answer, and I'll address further if need be based upon that yes or no. The microphone is unmuted. Actually, we'll need to turn
you are on
him
record.
up. It's not very loud on our end. Mr. Brooks, did you say one more time?
No.
Yeah, but you know what? Your volume's a little low, so we're gonna have them adjusted over there and in here. So give us a second. Mr. Brooks? Try again.
Am I on the record?
You are on the record. Ooh, that's loud now. We'll turn ours down. Mr. Brooks, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday?
Like, you see what he did right there? Like, he did that noise. Like, let me get you back. And look at his right hand when he moves. You see that? See this hand? He's moving the microphone next to the other. There are two microphones there. So they're here. You cannot see it on the screen, but he's moving the microphone together, and he causes that noise. Look at that.
Go ahead, answer, please. All right, your objection is noted for the record, and I'm just putting the mute back on. He provided that objection without any legal basis. I muted him just so I could ask this question. I'll be right with you, Captain.
Also, put on the shirt, dude. Who cares? Like, I don't see why he needs to get his shirt off. Like, I really cannot comprehend why you will take the shirt off. Do you guys have anything? Okay, put it in the comments if you know, if you can tell why he's doing this. I really don't get it.
Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you. Hold on, the volume is not being appropriate at the moment. There needs. Try it again, sir. I apologize for the technical issue. All right, the technical, we're gonna have to figure that out. It's not appropriately working. I do appreciate that he was able to hear me because he leaned in to answer, so I just want to make that right.
Yeah, she keeps telling that he can hear her. Like, he doesn't have any headphones, he's just doing it. Even with the technical difficulties with the audio, they can hear him. He can hear what she says. So that's really cool by the judge to point that out.
Record, I'll take, I'm gonna go take a recess. I'll just mute while we're doing that. When I needed to take the break for the audio issue, I also was advised by the captain that Mr. Brooks was requesting medical attention and reporting a small cut to a finger as a result of when he was removed from this courtroom and taken to the other courtroom. I was further advised that there are no signs of blood, and that when asked, he refused to show his hands. At this time, I'm not going to pause the proceedings further for him to be seen by jail medical, but at an appropriate break, that will be done. Now, I want to turn back to the issue with the jury instructions, Mr. Brooks. You indicated you had an objection. My next question to you is, what is the legal basis for the objection? I'm going to unmute so you can answer. Go ahead, sir. You need to turn around so I can hear you. Part of the issue is he's also not facing the microphone, and so I need to hear him, and he needs to turn around.
Yeah, and also don't be a baby. Don't just, like, she's sitting on the desk. Like, why? There's a chair right there. Just sit properly. This is a kid. This is a child.
Mr. Brooks, I'll ask you once again, what is the legal basis for your objection to the jury instructions?
No response. Move on.
I'll ask a third and final time, sir, what is the legal basis for your objection to the jury instructions?
I wasn't allowed to make, I can't even hear what she's saying all the way, man.
Yeah, turn around to the speakers. Like, he's doing this, and she's like, I cannot hear her. Why? What's wrong? Like, you can hear her. You.
She's too low.
You want your headset?
Mr. Brooks, I can hear the deputies over there. I know they can hear me. That's been confirmed. There is the headset available to use should you wish to use it. If you can't hear, I would ask that you put them on.
Mr. Brooks? You just put it down.
I'm able.
See? He's like, I cannot even hear her. Okay, here are the headphones. You can hear her now. Nah, just put it there. I don't even care.
Here he said to the deputy, put them down. I don't want them. All right, I'm going to mute once again so I continue with my record. He did not answer the question, what is the legal basis for the objection? I asked that question 3 times based upon that non-response. His objection is noted for the record, and I will approve the preliminary jury instructions that are on file with the court. Obviously, they'll be uploaded once I read them, but all parties have been given copies of those. Before I turn to the motion for reconsideration, you raised this earlier, at least the topic of it. Mr. Brooks presented a filing to the court this morning. To me, it just looks like an objection that he's filing, and that will be, of course, noted for the record. Attorney Opper, anything you would want to add to the record on this, any position you are taking?
No, I also viewed this as, because he labeled it objection by affidavit, I think my interpretation is he was trying to make a record for appeal that he objects to the court's previous ruling. I don't think there's anything the court needs to do with this document at this time.
All right, thank you. Then we'll move on to the motion for reconsideration. And again, I'm keeping Mr. Brooks muted so that I can get through this process orderly, efficiently. When necessary, I will unmute him if the court has questions. All right, Attorney Opper, I have read through the motion. Is there anything you want to add to what you have put in your filing?
Only one other observation, Your Honor, that since I filed that, the events of the last couple of days, I think further support my request. Not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior will be additional challenge to them as they testify, and so not having their faces displayed, I think, would help ease some of that tension for those individuals.
And let's be real. Every witness that was in the stand, that all of them were questioned by Brooks, and all of them were asked really inappropriate questions, really insensitive questions about what happened. And is putting a good argument here that they may, if they're not shown to the camera, because people get nervous in front of the camera. Like I'm here talking to you in front of the camera and I feel nervous, but being in that stage for something that important puts some pressure in you. So it's a good thing.
Mr. Brooks, my first question to you is, do you have a position on the state's request in their motion for reconsideration? I'm looking for a yes or no answer. I'll unmute and provide that to me. Go ahead.
I didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
You put the headphones before she started speaking, so you hear that. You heard that.
Sir, it's a written document that was filed, and you were provided a copy of that yesterday. The denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces, while they testify.
A ruling was already, we already talked about that. You already ruled that the victims and witnesses will be shown. That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document that was provided to you yesterday. I'm asking if you have any position on the request that I reconsider my ruling.
Yeah, it was everything's supposed to be public. This is a public trial. I don't understand why there would be even the need to reconsider what you already ruled on.
I understand it won't be easy. It may be messy. It may even be stressful. In my humble opinion, the right to a public trial supersedes the other provisions, and especially in a case such as this, it's important. I want to keep this trial going, and that's what we will do. So the request is denied.
Your Honor, if I may, I don't want to interrupt, but I did not hear if you, I was kind of overhearing that you addressed the filing that I filed this morning. I didn't hear exactly what was said. I'm just making sure that you know that I'm not trying to interrupt. I just want clarification on what I may have missed.
I'll tell you what I ruled previously. I've reviewed the filing. It's entitled Objection by Affidavit. No relief was requested, but also there's no statutory or constitutional or law that you cite to that I could even interpret as a request for relief. So that's how I'm going to address that filing, sir. It's noted for the record.
Can I say one thing about that?
Quickly, sir. I need to keep going.
I was filing that paperwork. I would say pursuant to the federal rules of criminal procedure under.
If you were doing that, then put it on the paper. Like, you cannot just write whatever and then be like, oh, here is the complementary information that I needed to have in the first place. Put it all together.
Rule 12.4 about the disclosure statement.
All right, I'll note that for the record, sir, but it was not in your filing.
Yeah.
So that's a judicial determination, Your Honor?
Yeah.
I believe I had one other thing. Oh, I did want to put on the record, and that is when we were testing the audio, I did advise the Sheriff's Department to let Mr. Brooks know, to ask him on my behalf if he wanted to come back into this courtroom. My understanding is he declined.
No, that is not accurate, Your Honor.
Mr. Brooks?
The reason?
Mr. Brooks?
I would just want it.
Hold on, I'm going to mute you for a second unless you stop and listen to me.
I just heard what you said, but
I'm not asking for a response, sir. Mr. Brooks?
It's not.
Okay,
not
you're
hybrid,
interrupting. Hold on. You're interrupting me, sir. I wasn't looking for a response. I'm happy to ask you the question myself on the record for you to answer it. I will ask you, sir, do you want to come back into this courtroom? You've been unmuted to answer that question.
Not until I can receive medical treatment for the bruise that I have on my arm and the cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants and you can still see the blood in the cut and a big bruise right here on my arm.
What do you want them to do about a bruise and a small cut? Like, it's not even bleeding anymore. Who cares?
I was told that the nurse would be coming in to see me, and then I was told, no, she's going to come at the next recess, which we just took. I know it was technical difficulties why you called the recess, but that was more than enough time for me to at least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum that, and for somebody to look at this bruise. That was my position on why I was not yet ready to come back into the court, because I feel like this needs to be addressed.
All right, Mr. Brooks, I understand your request. I'm denying the request to take an adjournment, or I'm sorry, to take a break at this time.
No, I'm not asking for a break. I didn't ask for a break. I was just saying that at the time that there was the technical difficulty recess, before you even called that, Your Honor, I was told that a nurse was coming in at that time. But then when you called the recess for the technical difficulty, I was then told that I would have to wait until another recess to be able to be seen by the nurse.
Dude acts like he's trying to bleed out. He's bleeding out right now on the floor. Like, it's not that urgent. You don't need to do that right now.
My thing was,
Mr. Brooks, you've made your record, okay? I don't need you to go further with that. You've made your record. I'm going to mute you for the time being. I want you to be aware, sir, I was advised regarding the cut. The bruise is new information. I made a determination that you would be seen at the next appropriate break. From my perspective, a small cut and a bruise is not going to hold up the start of bringing the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is for lunch and that's when you are seen, then that's what will happen. So I don't think I've overlooked anything, Attorney Opper, but anything you had on your list?
Nothing else on my list, but we want to give Mr. Brooks one more opportunity to change out of his orange jail uniform. Excuse me.
That I would give him an opportunity to do. Mr. Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to. Just like I should be awarded the right to be present for every proceedings in this trial.
All right, I'm muting him again. Then with that, I am going to just take a short recess just to have the jurors brought in.
All right, and with that, we're gonna finish this episode. Thank you guys for watching. I'll see you guys on the next one. Have a great day. Bye-bye.